Thank you, Jessica. It was a very comprehensive presentation of the rationale behind the new recommendation, but also its content. I have a question sort of referring to what Laurent Redel mentioned before about speeding up investigations. Is there anything in the new recommendation supporting this agenda of making criminal investigations more efficient, or taking this into account, because this is something that affects the total numbers in prison?
Yes, we have discussed these matters also at our expert meetings that we held in June of last year, and then obviously we also come to the question of the issue of maximum time limits that will be discussed later on in the panel also. We found out also, because of the input as a result of the consultations and of our meetings, that imposing a maximum time limit for pretrial detention was not desirable at this stage. Well, what we see is that there are huge differences between the maximum time limits in the member states. That was also an outcome of our study. And where actually we found out that the maximum time limits across the 27 EU member states differs from less than 1 year to more than 5 years. And there are, for example, 6 EU member states who also do not have a maximum time limit. Less than 1 year are, for example, Austria, Germany, Denmark, and the more than 5 years are member states like Italy and Romania. But we were not in a position actually to provide such a maximum time limit in the recommendation, and there are various reasons for that, and we will come to that, I suppose, also in the context of the panel. But the most complicated issue is obviously that it very much depends on the complexity of the investigation. That there are no general norms to be set, and there's also a risk that a maximum time limit might become the norm once it has been established. So also for less serious cases, that those actually will then, the time will be used that is allowed, will be allowed under national or EU guidance. So that's actually the reason why we haven't touched upon that. We have actually provisions in the recommendation that matters relating to pre-trial detention should be dealt with as a priority. So I mean, in that way, we address the matter, I mean, indirectly. So I hope that answers your question.
Thank you. We have a question here in the Q&A regarding the situation and also the position of the European Commission on children of imprisoned parents. And there is a specific Council of Europe recommendation on this, as you of course know. And regarding the access to visits and communication with incarcerated parents, is there anything in this new recommendation addressing this issue, and what is the Commission's position on this?
Yes, thank you. Yeah. I mean, we have obviously we as I said, I mean, we could not address all the issues. Actually, in the recommendation, we went already much further than we expected in the first place, because initially, we were intending to limit ourselves to the issues that had been identified by the European Court of Justice also in this case law. So that's mostly related to the square meters available, to the time outside the cell, to health issues. But during the exercise, we realized that we could not limit ourselves to those 5 basic elements concerning material detention conditions. So we have actually enlarged a lot already, and we do have provisions on the possibility of visits also that specific rooms should be made available also for children to be able to meet their parents, so that the surroundings will be less dramatic for children. So to take special take that into account. It is certainly also a priority of the Commission to deal with this matter. We also see it, as I said, in the case law. There's currently a case where there is a Belgian mother an EAW from Belgium to Italy for a mother of a young child to be surrendered. And that will also be a very interesting decision, as the court will be obliged to rule on the position of the child, whether it will be in the interest of the child to join the mother and to be detained in Belgium, what the conditions in the Belgian prisons are. So there are many elements that will soon be clarified also by the Court of Justice in that respect.
Thank you, Jeska. Before we proceed, I see that we have a comment from our French colleagues. Mr. Redel, would you please like to make a comment on the length of investigations?
Oui, merci. Effectivement,
yes, thank you very much. Indeed, investigation times in France are very long, as I said earlier, and this is also due to the time period necessary for hearings, because once the investigation has finished, sometimes it's a long time before the cour d'assises, so the court that hears these cases has time to look at this, and we are once again dealing with a problem with legal resources. So there's the problem with the investigation time, but there are also problems with the resources necessary for a court hearing. And in addition to that, in France now you can appeal the rulings by the Assize Court, and this increases that difficulty. And during that waiting period, the people stay in the remand centers, so in pretrial detention. And so this is a very serious problem that needs to be resolved in France. We need to improve that situation in France.
Thank you. We might get back to this question later in the panel. Again, thank you so much for these two very interesting introductory presentations. We will now move on to the panel discussion, and I leave to Olivia to introduce the panelists. Just before handing over to you, I would like to remind the participants to name yourself before submitting a question, so we know who's asking questions and also who's participating in this event. Thank you.
Thank you, Gustav, and good afternoon, good evening to all of you joining here. It's a pleasure to be moderating the second half of this discussion. I'm the Executive Director of Penal Reform International, and we're thrilled to join up with EuroPris and all of you colleagues today to discuss pretrial detention, which is I would say a challenge to most criminal justice systems globally. We are joined by a great panel with some experts with different perspectives. They all sit in different seats or different parts of the criminal justice system, and together have a very impressive amount of experience. So let me shortly introduce them, and then we will get into some questions. So firstly, we have Kam Stevens, who is a filmmaker, prison reform advocate, and program facilitator. He's become a powerful voice in prison reform and a shining example of what is possible when those with lived experience stepped forward to lead the way. Welcome, Kam. Adriano Martufi brings a wealth of knowledge from his academic career. Among his extensive publishing career, Adriano has recently edited a special issue titled Towards an Evidence-Based Approach to Pretrial Detention in Europe, which is exactly what we need to hear about today. We're also joined by Ioana Morar, who is the Director of the Social Reintegration Directorate in Romania. She has almost 2 decades of experience working with the penitentiary system and also in other countries where she has provided expertise on detention conditions, etc., in line with international standards. And last but not least, welcome to Jessica Vonderscher, who is a public prosecutor in France currently, having previously served as a judge. And among many other accolades, she has participated in the creation of the Community Service and Professional Integration Agency, where she heads the Community Service Department. So thank you, panelists. It's really a pleasure to have you all and have different perspectives from you. The first question I wanted to pose, and perhaps I can start with you, Adriano, is we see that pretrial detention is not used exceptionally. In fact, international standards are very clear that it should be a measure of last resort. One reason that I've heard for this fact is that politicians or even the system, including judges and so on, are responding to a presumed wish that society want people detained until proven innocent rather than the other way round. What's your take on this? Do you think that this assumption of what the public want is correct? And how do you see this playing out?
Well, thank you so much, Olivia, for your question. Thank you, Gustav and EuroPris in general for this kind invitation. So I would like to react very briefly to this very challenging question, which will take me much longer actually to be answered properly. But I mean, I would say, so the answer might be twofold. So from a legal perspective, one could say that indeed there are procedural safeguards in place to prevent politics and politicians to actually influence decision-making procedures when it comes to the alternative between bail and detention. And I'm thinking in particular about what the European Court of Human Rights has said concerning the guarantees of independence of judicial authorities in charge of decisions concerning pre-trial detention. So they must be, among other things, independent of the executive, therefore from the government when they take decisions. So authorities such as the magistrate court in England and Wales or the juge d'instruction in France are must be demonstrably independent as judicial authorities to be actually in charge of those decisions. So these are procedural safeguards, of course, that exist when it comes to the law in the books. Of course, the law in practice tells us something different, unfortunately, and it's also consistently demonstrated by research and evidence that has been accumulated in the last few years, including in our special issue, that prosecutors and judges as well are extremely vulnerable to political pressures and political influences when it comes to those decisions. A study that we reported in our special issue concerning pretrial decision-making in Italy, pretrial detention decision-making in Italy, actually stated that at least 40% of the judges interviewed during the research acknowledged that they were wary of the consequences of a potential release on bail of suspects during trial and the outcry this might generate on social media, in the public opinion overall, and in the press. And there's another element that I would like to state in this respect. I mean, the often understated importance of police leading investigation and the influence that the clouds of especially some police officers might exercise on prosecutors and judges, and the expectations that coming from the police that might influence indeed judicial decision making when it comes to the alternative between pretrial detention and bail. And we know, of course, that if judicial authorities are and must be independent, police should not, or is not necessarily, so it doesn't have to be subject to the same kind of level of guarantees, and is more prone to political priorities. So I think these are the two elements that I would like to.
So if I can, thank you, Adriano. If I can just pick up on that point and pose the question to you, Jessica, as a public prosecutor and a judge. How do you see that? How do you practically overcome this perhaps legitimate concern of judges that if something goes wrong when they let a suspect out, you know, of pretrial detention? How do we overcome this problem, which we have heard from many countries, in fact, outside of Europe too?
Oui, bonjour Olivia et merci pour cette question. Bonjour à tous et je salue aussi monsieur le directeur de l'administration pénitentiaire française.
Yeah, thank you very much, Olivia, and greetings also to the head of the penitentiary administration in France. So, in France, we have an antagonistic situation, and there are, in a way, double standards, or a speech that public discourse that is contradictory. On the one hand, there is this ambition to actually have more prisons, more cells built, etc. And on the other hand, there's also an injunction to find alternatives to detention. So this doesn't help clarify the situation, because in a way it's going in opposite directions in public discourse. But there is not just political pressure, there's also media pressure. Very often, in current affairs, the only thing that media are interested is the numbers of years that are part of the sentencing. And then investigators, like public opinion, consider that prison is the natural outcome, as it were. Now, of course, we can do things to make the situation change. And this is also why I actually resumed with my career as prosecutor after working on something else. We have started working on a sort of counter discourse, explaining to all local stakeholders how alternatives to detention are interesting. Prisons also, in a way, are creating a ground that is rife for criminality, and this obviously should not be the case. And the statistics here are really dire. When you actually talk to the mayors, to the investigators at the gendarmerie, and that actually sentencing to public interest work is something that is very convincing, and they all see how this could be a good alternative. So would you like me to actually carry on and to elaborate on what I've just said? So regarding the magistrate, so prosecutors, I don't know what it is in other countries. So prosecutors hierarchically are dependent on the Ministry of Justice, are in a hierarchical relation, but they also guarantee the compliance with human rights and dignity. And I know that where I work, we pay great attention to overcrowding, to, for example, mattresses being added to cells that should host one inmate only. And so we do work with the prisons, and we spend quite a lot of time calling those prisons, and we find out where actually detention can be carried out, that detention can be carried out in conditions that are compliant with human dignity before sentencing. I can't hear anyone.
Sorry, I was on mute. Sorry. Thank you, Jessica. I was saying that that's a helpful initiative to share. Something you mentioned around, you know, sort of the media pressure and harnessing perhaps storytelling. And Kam, I'm going to look to you now, because I think, you know, evidencing and more so sharing the harmful impacts of pretrial detention, you know, is perhaps one way to address this natural outcome of prison being used in criminal cases. From your point of view, how do you think we need to move forward in that respect? What can we do?
So unfortunately, the media has got a lot of influence on public opinion. And until we start to show, I guess, people in a more humanistic approach and that people can turn their lives around, it kind of reinforces the rhetoric that anybody who goes into prison is a bad person. Now, when it comes to pretrial detention, somebody going into pretrial detention, they might be innocent, they might not. They might have committed a crime or they might be innocent. But the point of a prison is to be a rehabilitative environment for people to get better and go back into society and be good members of that society. But at the moment, the way that the current system is set up, we have some of the hardest and most complicated people in society coming into one place, and the rhetoric is be tough on them. Now, all we're doing is creating more tougher criminals, right? Because they're in this environment and all they're going to do is survive. That's all they know how to do. So us bringing people in on pretrial detention, we are just exposing them and toughening them in criminality. When me myself, when I went into prison, I lost everything. I lost my credit score, I lost my house, I lost my family, and all I had was my relationships that I built in prison. Now, me coming out into, I guess, back into society, I made positive relationships. I worked with prison reformers, I worked with charities, I worked with people that wanted to go in the same direction as me and do something positive with their life. But unfortunately, prison is about survival, and it takes a really brave person to be able to step out and do that. And not everybody is as brave as that. So unfortunately, people just tend to mirror what they're seeing so they can survive. And now the tools that they learn in prison, unfortunately, are, I guess, ones that always bring them back into criminality, because it's what they've used to, it's what they've learned how to survive with. So we definitely need to be doing more alternatives to prisons, so we don't put people into that situation in the first place where whether they're innocent or guilty, that we need to limit it, because it's causing more harm to our societies than the prevention of actually putting somebody in there in the first place.
Yeah, thank you. I'll just briefly raise a challenge that you've pointed to, Kam, around the conditions. And if I can turn to Ioana, and then we will go to some questions from participants. But I think one of the main challenges also with access to justice brought by pretrial detention is that once you're in detention, it's quite difficult to sometimes access legal representation, and studies have shown actually that outcomes in court for people in pretrial detention are usually worse than if somebody is at liberty and can prepare for their case in the community. Ioana, from where you sit, how do you see sort of the prison management challenges with pretrial detention in that regard?
Thank you, Olivia. And of course, thank you for the invitation. It is an honor for me to contribute from the perspective of the Romanian prison system. And yes, definitely an effective management of places of detention in compliance with international recommendations, targeting, of course, inmates' successful transition to the community, and reducing the risk of reoffending, and also taking into consideration the pretrial detention challenges constitute, beyond any doubt, an extremely complex mission for the management of any prison system. Therefore, I think European and international best practices should be shared and distributed. for the benefit of the criminal justice system. And from this perspective, I appreciate and convey my congratulations for the initiative of organizing this webinar, both to EuroPris and Penal Reform International. I think this topic is an extremely useful one because discussing pretrial detention, its impact on prison overcrowding and disproportionate application for some population must be discussed not only between practitioners in the prison system, but also among academics and NGOs. And of course, dealing effectively with the overuse of pretrial detention needs to begin with a clear understanding of the causes and the context of this practice in a particular environment. I could offer, of course, some practices related to Romanian prison system, and this would be my contribution. And also I would like to mention that there is also a larger interview on this topic published by Justice Trends magazine. It's an interview of the General Director of the Romanian prison system published last year. So Romanian prison administration constantly highlighted that excessive pretrial detention has a negative impact, and on the prison side, we've constantly highlighted that it's necessary to take measures, and that the uncertainty related to this category of detainees or persons has a serious impact on rehabilitation and sentence execution planning, because everything is put on hold. In 2003, for example, when out of the total of the prison population in Romania exceeded 48,000 inmates, Romania introduced some legal amendments specific addressing pretrial detention. And after this bill, there was a significant drop in pretrial detainees. Also, another important milestone related to pretrial detention from the perspective of the legislature initiatives was in 2014, when the penal reform measures adopted by Romania led to the entry into force of a new penal code, a new code of criminal procedure, and a new law on the execution of custodial sentences. And following the entry into force of this package of laws, of course, the new preventive measures that were adopted resulted in a decrease in number of remanded inmates by nearly 50%. We consider that this feat has been achieved through the courts progressively applying more alternative non-custodial measures, such as judicial control and house arrest. And currently, we are, of course, in the same trend of decreasing the number of individuals that are under pretrial detention in our custody. Even more so, I can mention that in 2020, Romanian Parliament adopted a new bill that provides a legal basis and guidelines to implement the electronic monitoring of offenders as an alternative measure to imprisonment. So we are extremely confident that once this system is put in place, the number of pretrial inmates will continue to decrease. So these alternative preventive measures resulted to be extremely effective on diminishing the number of pretrial detainees under our custody. And of course, from the perspective of the programs and assistance that we need to ensure for pretrial detainees, we must take into consideration also infrastructure and everything that is conducive to offering them a better assistance, like including transformative programming and any other kind of cooperations with let's say, the community in terms of bettering and ensuring a complex array of services for them.
Thanks, Ioana. And I like that you got us onto solutions there as well, because I'll hand over to Gustav. I see some interesting questions on the Q&A, so we will try and answer a couple of them.
Thanks, Olivia. Well, there is one question here that is very general, I would say, but it's sort of targeting the efficiency of the measure in itself. And this is maybe for several panelists to respond to. So what qualitative criteria can be used to measure the efficiency of pretrial detention, and how can you then measure it? So this is from Alexander Moiseyev, and it's not addressed to specific panelists, but I think this is an interesting topic in terms of efficiency of the instrument in itself.
All right, so I'd like to take a stab at that one. So if you measure, I guess, the cost of incarcerating somebody for a year, right, on pretrial detention, and then you measure the cost of having somebody out in the community, and then if you can calculate if that person goes into prison, comes out and reoffends, and what amount of impact is that going to have on society? What is the societal value of that? Someone going into the system, I guess, getting influenced by the people that he meets in there or she meets in there to come out, or somebody who's in the community and has a little bit more support. So if you just gauge the two, I guess you'll be able to come to a dollar value of what the impact of that is.
Can I also suggest one possible consideration also in measuring is around the conviction rates. So where you have very high rates of pretrial detention, or even, you know, medium rates in terms of the world rankings of pretrial detention, I think looking at the actual conviction rates after that period, and not to mention all the harms in between, there needs to be some sort of correlation, because that shows whether the measure is being used proportionately. So if you have low conviction rates but high pretrial detention rates, there's some kind of systemic problem there, and that's where you then, as was said previously, you look at the drivers and so on of those rates.
Yeah, and if I may add just a few words on this, just want to say that, just picking up on what you said, Olivia, I guess we definitely need some longitudinal studies to look at what happens with the passing of time to men, women, and other individuals who are subject to pretrial detention, and following the path throughout the criminal justice system and the number of miscarriages of justice that might take place in relation to that. That's extremely important. It's a very, very difficult measurement, of course, but it requires following a number of individuals across time and space, and sometimes involving you know, a lot of sensible data concerning those people. But it's extremely important to actually analyze how this functionality of remand and custody and pretrial detention within a given criminal justice system actually is.
All right, guys, I've just got 2 points that I wanted to add. So Keith Fraser is the chief of the youth board here in the UK. He posted some statistics this week that said almost 3/4 of children on pretrial detention in the UK get released on public order sentences. So they get community sentences. So with those kind of figures, there is something clearly wrong with, I guess, the court system to be sending these people, these young children, into these very hostile places, because the youth prison service over here is one of the most violent places. I've been through the youth system myself, and it's really, really hard, really challenging people. So there's only about 500 people in the estate, but if 95% of those that are going in on pre-trial detention are getting released into the community on community-based punishments, it's clearly doing more harm. So, you know, that's the first thing. And the second question, in terms of, I guess, how you can capture the data around this, probably the most powerful piece of data that you could capture will be to do a documentary around it and follow these people. And through this documentary, you could capture all the impact of the family, the participants, the court system, and then you can push that out into the, I guess, the digital world. And that's how you're going to get the mass impact from, I guess, the work that you're doing. So that's another suggestion that I wanted to put to you as well.
Oui, alors je vais ajouter 2 points aussi pour du côté de la France.
I'd like to add 2 things from the French point of view. Pretrial detention is meant to guarantee efficient investigation, and 70% of our procedures are criminal procedures which involve very serious crimes. So very often with murder or very violent crimes or rape cases. And so the pretrial detention can be very long. But in most cases, the pretrial detention leads to an assize court condemnation. There are other cases in which we have the problem with the lack of resources and lack of investigating magistrates and lack of judges. And last week, for example, I went to work with some colleagues to look at some minor cases, and we looked at actually 1,000 of them, and they've dated back many years, and very often the investigators had just abandoned these cases in order to look at other cases which seemed to be more urgent and more serious.
Ioana.
I would like to also have a short intervention. Firstly, highlighting that definitely the recommendation of the European Commission will have a positive impact, and definitely there will be improvements in terms of alleviating some of the negative issues related to pretrial detention. So this is something to be congratulated. And from another perspective, taking into consideration that currently I am a Fulbright at University of Minnesota at Hubert Humphrey School of Public Affairs, and having been in contact and exposed to some of the US, let's say, practices, I would like to offer also the example of Minnesota State. They are focusing a lot on more community, like the motto is less confinement, more community. So community services and alternatives to detention are seriously taken into consideration. So because we have also participants from USA, I wanted to share also this practice, that it's important to be taken into consideration as well.
Gustav, do you want me to carry on, or do you have another question from the participants, perhaps?
So now we're warmed up apparently, because now the questions are flowing in here. So I would just try to summarize a few on the same topic. So there is a question repeated here about information, lack of information pre-trial, basically. And the most common question on this topic is, that the decision not to detain can be enhanced through provision of information by non-judicial personnel. Is this method of use in your jurisdictions? And if so, who are the personnel involved and what information do they provide? So it's about information about the, let's say, the risk and the possibilities of using the alternatives at hand. And it was not directed to a specific speaker, so it's more maybe mainly to the French and the Romanian representatives.
Merci Gustav. Alors, je vais reprendre l'exemple en fait.
Thank you. I'm going to look at the example that we talked about on domestic violence. We have a rate of pretrial detention and sentencing, which is very high. And we created two programs. One was regarding accelerated social investigations, either by the Penitentiary Association or by other family authorities in order to defend the idea of pretrial detention or not. We've also done victimization, victimology studies, which are done during the pretrial detention, which helps us to define the family environment and to know whether or not there's a risk of repeat offense and whether there are possibilities of alternative housing for the victim. We've also developed other systems with associations to work to find specialized housing systems outside of the penitentiary system, monitored by the penitentiary authorities, working with psychologists and work groups and people who are either awaiting trial for domestic violence or who have already been sentenced and who find themselves in special housing, but with the possibility to continue working and also to have access to special care. I would like to add something to what Madame Vonderscher just said. We also have a fourth system which enables us to limit pretrial detention for the for cases of domestic violence, and the number of people has increased because social pressure has increased, and domestic violence is now very seriously sanctioned. So we have developed partnerships with both with law enforcement organizations and with associations, victim defense associations, and we've adopted the use of electric bracelets to guarantee that the perpetrators do not go near the victims. The victims are guaranteed a certain safety zone, and they have an accelerated system for contacting the police. So it's a system a triangular system between the police, the magistrates, and the penitentiary systems, which are meant to keep the perpetrators away from the victims, but also out of prison so that they can keep their jobs.
From the perspective of the Romanian prison system, of course, our main focus is on ensuring the assistance for the incarcerated persons. Either we are focusing on pre-trial detention inmates or the ones that are inmates with definitive conviction. Of course, all programs that we are delivering or implementing with the participation of incarcerated persons are standardized one, are mainly developed in cooperation with the academics, because in different regions of the country, we have a cooperation agreement with different universities. So it was possible for us to develop programs and to benefit of their input or scientific coordination. Of course, we also have associations like nonprofit or NGOs that are cooperating with us, and at the level of each penitentiary unit, there are relevant contributions from this sector as well.
Any further thoughts on those questions, or I'll continue? Good, okay. Just to mix it up, we now have a short video which was produced by the NGO Fair Trials. It's called A Measure of Last Resort, Detention Without Trial in the EU. And it has some helpful input also from people who have been impacted by pre-trial detention. Eugenia, if you could, thank you.
Across Europe, there are over 120,000 people being detained in pre-trial detention. That's 1 in 5 people in prison who have not been found guilty of a crime. Detained without trial and for an indefinite period, the impact can be devastating. But what's it actually like in pre-trial detention?
În 21 februarie 2001 am venit la secția de poliție cu convingerea faptului că sunt martor într-un dosar penal și am plecat acasă după 1 an și 9 luni.
Aveva una pistola a mano e tremava la mano, che mi ha fatto spaventare. Mi ha avvicinato: fermati, spegni il motore, esci fuori in ginocchio, mani in alto, non ti muovere, ti sparo.
To się wydarzyło tak, jak to często na filmach pokazują. O godzinie 6 rano przyszła policja. No, od razu mi skłuto ręce w kajdanki i pokazano nakaz rewizji mieszkania.
After the shock of an arrest, a detention center can be a terrifying prospect.
Arestul Poliției Capitalei de la momentul ăla arăta ca o grotă. Era la subsol.
Wcześniej no, więzienie znałem z programów telewizyjnych, z filmów. No, pierwszy raz się znalazłem po tej drugiej stronie, no to kolejny szok. No. Całkowicie nowa dla mnie sytuacja, nowe otoczenie, no takie wrażenia no nie za ciekawe, nie wesołe, no mocno przytłaczające.
Non hai diritto di parlare con qualcuno.
Once detained, you should be entitled to a detention review hearing, a chance to tell your side.
Non mi ricordo neanche quante udienze abbiamo fatto, quindi ogni sforzo, diciamo, era rigettata, cioè non accolta.
N-am fost audiată niciodată. Atunci când mergeam în fața instanței la prelungirea sau menținerea măsurii arestului preventiv, nici măcar nu eram întrebată ceva. Niciodată.
Czasami przecinki, kropki i wszelkie znaki interpunkcyjne były nawet w tym samym miejscu postawione, tak jakby zrobić Ctrl-C, Ctrl-V skopiuj.
The effects of pre-trial detention don't always end with release.
E perdi tutto, cioè perdi il lavoro, perdi l'immagine, non solo in Italia ma anche il paese tuo, perché ti sbattono i primi pagine dei giornali e poi fai la fatica di trovare una sistemazione.
De la momentul când am fost eliberată, în opinia mea, mi-au trebuit 15 ani ca viața mea să revină la normal, aproape de normal măcar.
Between them, Maciek, Bruno and Daniela spent 6 years in prison. Bruno and Daniela were eventually acquitted of any wrongdoing. Maciek's wait for a verdict continues.
Jestem tutaj, to w ogóle nie da się tego porównać, no to jest pod każdym względem, no to wiadomo, no to każdy marzy o tym, żeby każdy, kto siedział w więzieniu, no to marzy o tym, żeby właśnie już, jeżeli to ma trwać, to żeby to trwało, żeby to wyglądało w taki sposób, że można normalnie z wolności przychodzić i inne sprawy.
Fair Trials is campaigning for an end to unjustified pre-trial detention. Find out more at fairtrials.org.
Thank you, Olivia. I'm conscious of the time and I do want to get onto solutions. So I wanted to pose this question to all of you panelists. If there is a good initiative or a reform or a recommendation that you have around reducing pre-trial detention or improving the system we have with pre-trial detention as a measure, it would be great if you could share that with participants so that we can inspire some more thinking and share information. Kam, if I can start with you.
Hi guys, yeah, sorry. I think one thing is, I think that, the European Union has put in this framework, but nobody seems to really be following it. I think it needs to be a lot more, I guess, enforceable, because in regards to, I guess, the government in the UK, okay, the European Union can make its recommendations, but how stringent are they in following these recommendations? How much is that getting filtered down to the people that are making the decisions in the court? I think training, I guess, the people who are in charge of, I guess, putting people in custody as well and letting them know what the impacts of this is, and how people's lives are really getting affected by this would be a really good shout, because maybe then they'll start to make a decision like, do I really send this person to prison? If the European Union is saying this is the course, then maybe I need to try and look for more, I guess, alternatives to prison instead of putting young people and, I guess, the adult population in a place that is not going to be good for their personal growth without due course. And I guess, yeah, something.
I think capacity and information of, the decision makers around detention is a very important thing, which Jessica mentioned, like ringing the prison, checking the overcrowding rates, what are the detention conditions, and this is also linked to, the EU framework decisions and so on. Adriano, what about on your side? I know, you've kind of researched a lot of the systems. What good example or what more positive solution do you have to propose?
Well, thank you. So hopefully my mic works better right now. And so be very, very brief. Suggestions we made in several publications, and I will take the liberty to reproduce it right now with you today, is to scale down the use of pre-trial detention for as a measure to prevent reoffending and to tackle disturbances or threats to public order. So we have consistent data that show that the rate of pretrial detainees tend to grow in those jurisdictions that are using pretrial detention as a preventive measure more frequently to deal with reoffending instead of a simple means to secure the presence of suspects at trial. So of course we cannot ask to repeal these grounds for pretrial detention altogether. We are very much aware of that. But what we demand as a community of scholars, and on the basis of research we have made comparatively and on the basis of the data we collected, is to at least make provisions in the jurisdictions that allow for this kind of pretrial detention to be ordered, to have a higher, to require a higher standard of evidence to order pretrial detention, in the knowledge that pretrial detention order to prevent reoffending is something completely different than a simple procedural means to secure that the person is actually present at trial, or that they do not tamper with evidence. So these are two different means to deal with suspects during trial, and we demand also on the basis of the presumption of innocence that those people, of course, have the right to, that a higher standard of evidence is required to order pretrial detention against, in order to prevent reoffending, so on preventive grounds, so to speak.
Thank you. Ioana?
Thank you, Olivia. Definitely cases like the case that was presented, that of Daniela from 2001, determined the improvements that our legislation already had. And of course, this is work in progress, meaning that we need to keep up with that. And the recommendation of the European Commission is already in the process of being analyzed and to be determined concrete steps for its implementation in the Romanian prison system. Also, what's very important to mention in terms of the specific of Romania's criminal justice system is that the arrests that Daniela mentioned in the video are under the Ministry of Interior, and we only have the prisons and the penitentiary hospitals and the detention centers under the coordination of the Romanian National Administration of Penitentiaries. But I totally agree on a larger scale with Kam that we need to focus on rehabilitation. This is the main function of any prison system, and consistent steps should be taken in this respect. Of course, there was a large improvement, a consistent and robust one related to the Romanian prison system as well. But we are in the same context and in the same time aware of the fact that we need to improve that we need transforming programming, and that we need more evidence-based practices in order to ensure an efficacious or an effective rehabilitation.
Thanks, Ioana. And Jessica, Mr. Riddell mentioned, the new package of laws, including electronic monitoring and so on, as a solution to reduce the number of people in pre-trial in France. But do you have anything else you can share that's, either recommended or in practice?
Alors, je pense qu'il y a trois idées fortes qui ne sont pas encore en vigueur en France. La première, ce serait celle d'un numerus clausus.
There are three main ideas that haven't been implemented. For example, a numerus clausus, which would mean that the first one would be to address overpopulation. Then the head of the penitentiary administration mentioned legislative changes. However, overcrowding in prisons has not been solved, and in the last 20 years, it has constantly risen in France. During the last legislature, we have had 150 bills that have been passed. This creates a lack of visibility, a lack of safety in judicial decision-making process. You cannot actually assimilate 150 laws within 5 years, even if you're the most brilliant legal mind. And so therefore you tend to opt for the simplest solution, which is the by default solution, that is sentencing to detention. And then there is a third option, something that where we can actually take some inspiration from Canada, something that is not so much focused on the offense or the crime, but actually the cause of it. And when a sentence is handed over, the idea in the long term is to protect society. And there, the answer is that detention is not necessarily the best solution. In this different approach to justice, there is also something that is actually more horizontal, where more stakeholders of the judiciary are taking part. And so in Belfort, we did this, bringing together magistrates, prosecution, investigative police, everyone, in order to agree on the same sort of framework, the same analysis, in order to establish a sort of standard that is shared by everyone.
Thank you very much, Jessica. And I think that's a great segue into a few concluding or overall points that I think may help for people to take away. It's impossible to summarize today's rich discussion, but a few things that I have noted is the importance around monitoring. How do we monitor whether pretrial detention is being used effectively or excessively? Is it being used only necessarily? And how do we reduce the harms of pretrial detention? There has also been quite a lot of chat around information for decision makers, requiring a higher level of evidence, to quote Adriano, a tighter criteria for when pretrial detention is used so that we fulfill this international standards. And around the international standards, and particularly EU and Council of Europe standards, how do we translate them? How do we get them to be used in everyday practice of decision makers? We need more capacity building so they can use the jurisprudence, they can use the standards in their decisions and feel confident enough to. And that is linked to the last point that I'm taking away, is around the perhaps the underestimation we put on the media and their influence, and the need to educate the media and to make sure that they report ethically around criminal justice issues, using evidence. And people like Kam, who are out there, you know, as an advocate and telling the stories, and the Fair Trials video that we saw, we need more of that, and we need it to be more strategic, so that this pressure on, you know, politicians and this tough on crime rhetoric can be challenged seriously, because that is definitely a driver of pretrial detention, I think we've heard today. So I will leave it there, but thank you very much to the panelists. I think it was a very good discussion, and hopefully just the start of a solution, action-oriented discussion at this level. So Gustav, if I can hand back to you.
Thank you so much, Olivia. I'm so proud and happy to be able to organize this webinar. And as you have noticed, we at EuroPris and PRI, we realized that issues in prison cannot be discussed only with prison professionals. So we need to include civil society, people with lived experience, and also the judiciary and the legal professionals to discuss these issues, because otherwise we cannot move forward in terms of overcrowding and detention conditions. So this is part of the mission of EuroPris to try to broaden the discussion in this way, the way that we do today. I will, before we wrap up, just briefly show you a function on our website And it is let me see. Can you see my browser now? Can you see my browser?
Yes, we can.
Thank you. So I will just show you briefly. There is something called EPIS, which is our database for prison services in Europe. If you click statistics, you end up in a section with graphs with the key information about European prison detention conditions. And if we scroll down, I will just briefly show you how it works. Here we have a graph of percentage of inmates without the final sentence in the prison population. So that is basically the pre-trial population. And just to give an example of the possibility of using these graphs, we can add France. This is the development of pre-trial in France and Romania, as we have representatives for these countries. And here you can clearly see an illustration of what's been discussed today. So you have the reforms in around 2010 in Romania, making the drop of the population in Romania in pre-trial. So these numbers can also be used to sort of analyze trends and compare the development in different countries. And there's a lot more of these kind of tools and comparisons in our website. So I would just like to remind you and recommend you to use these materials, which are open source. This specifically is a collaboration with the Space Consortium in Lausanne that also makes the space data. So I will stop sharing. And before we close the webinar, as I mentioned, we will do a short polling. Jenya, have you launched a polling? Thank you. So there are just a few questions addressing today's webinar. Please take some time and responding to your background and also your satisfaction with the webinar. And meanwhile you do that, I will also just again remind you that there will be an EU survey sent out via email. And this is procedure that we do because this webinar is part of the funding of the justice program of the European Commission. The recordings of this webinar will be edited shortly and published also on our website. So with those words, and I see now that the results are adding up on our screen. And it looks good. We have good and excellent results. And in terms of background, we can also see that there's a great mix of professionals, both from NGOs, governmental agencies, a lot of prison probation professionals, and also academia. So this is sort of a result that we can be happy with, I think. So again, many thanks to the speakers and the panelists of this webinar. Thanks, Olivia, for hosting and moderating the panel. And we will see you soon again, either in one of our events or in one of the events of PRI. And please check our websites for further information. Have a good afternoon.